Okay, here we go. True crime headlines. All right, so you know where Jimmy went to? Well, we're up where I met with Nanette, and where Jimmy went to college and grad school. That's called Broome County, New York. There was a horrific case up there today, and I mean not today, but I think it was. Hold on, let me just do this here. And it was a 26-year-old man, and he's been charged now with murder because Patrick Profrate, he argued with his wife early Monday morning, and she was holding their 3 months or 3 weeks. I forget if she's 3 months or 3 weeks. 3-week-old. Wow. So she's holding their 3-week-old baby, who's Eleanor Carey, and he fires a crossbow at his wife while she's holding the baby, and the bolt hit the infant in the upper torso, exited by the armpit, and it struck the mother in the chest, and it killed the baby. And he removed the bolt and attempted to stop the woman from calling 911, and then he fled the scene in his 2016 Dodge Ram pickup truck before responding deputies arrived. He left the crossbow behind. Deputies attempted life-saving measures when they arrived, and they carried the little girl, identified as Eleanor, carried out to paramedics who pronounced her dead. The baby's mother was taken to the hospital for treatment with assistance from the New York State Police and the Shenango County Sheriff's deputies. Broome County deputies set up a perimeter and set about a search, a manhunt for Profet. They found him hiding in the woods less than a mile from his Colesville home after he'd gotten his truck stuck in the mud. He was charged with second-degree murder, attempted second-degree murder, and criminal contempt for violating an order of protection. This is one of the most heartbreaking and senseless crimes committed in this community in recent memory, said the Broome County Sheriff Fred Aksher. Our thoughts are with the family of the innocent 3-week-old Eleanor Carey. Horrible. The sheriff's office said that he had a history of domestic violence against his wife, along with an active order of protection. Great. Unbelievable. Poor mother. Poor baby. What is this? Wow, there was a mass shooting at a Texas mall at the premium outlets. Did anybody know that? I've been like gone all day, and
No.
a neo-Nazi. Nobody knows this. Okay. My computer, whatever. Cooperate here. Remind me, I've got to restart my computer before I go live tomorrow. Okay, let's see what's going on here. Texas police released body cam footage on Wednesday. Oh, from May's. Oh, this is from May's mass shooting. So they released the body cam footage. The suspected gunman, alleged neo-Nazi Mauricio Garcia, 33, fatally shot the 8 victims at the Allen Premium Outlets on May 6th before being killed by law enforcement. An Allen police officer who was already at the outlet when the shooting occurred was filmed shooting the suspect as he approached him. Okay, so we have that dentist that poisoned his wife, well, allegedly. He gets a $10 million cash-only bond. And let's see. So we have the guy that poisoned his wife and the woman that allegedly poisoned her husband, allegedly both of them. Imagine if they got together. Crazy. Poisoning. Okay. The Colorado dentist accused of fatally poisoning his wife earlier this year was granted a $10 million cash-only bond after the state Supreme Court ruled last week that the judges must set bond in first-degree murder cases. James Craig, he's 45, he is arrested and charged with killing his wife with poison, 43-year-old Angela Craig, in March. She was hospitalized at UCH Health. Remember, we read all those texts. But she deteriorated rapidly before doctors declared her brain dead and removed her from life support. And he asked the doctors, don't do an autopsy on my wife. Okay, please. Then we read that 52-page affidavit. And let's see. So he's got a $10 million cash-only bond. And the other allegedly poisoner, Corey Richins, hold on, come over here. She. Come on. Come on. Get over there. Go on now. Go on. Get over there. So she's been sued with a lawsuit for $13 million, and it's filed by her husband's family, and it's filed on behalf of Katie Richins Benson, Eric Richins' sister, and the trustee of his estate. And it's filed against Corey because she has a lawsuit, saying that a prenup agreement makes her the rightful owner of her husband's property, even though he placed it in a trust with his sister before his death, because he suspected his wife. Remember, he thought she was trying to kill him with poison. So did the other woman that was poisoned by the dentist. So her, let me see if I can open this. Her lawsuit says that plaintiff Corey Richins, by and through her counsel of record, Ray Quinney and Nebuchadnezzar PC, hereby complains of and for her causes of action against Katie Richins Benson solely in her capacity as the trustee of Eric Richins Living Trust, dated November 3rd, 2020. States, alleges, and avers that follows. Hold on, come on, move. Oh my gosh. Computer is driving me crazy right now. Come on. Okay, here we go. Come on. The plaintiff, Corey Richins, is an individual residing in Summit County. Defendant Katie Richins Benson, the sister, is the trustee of Eric Richins Living Trust. Court has jurisdiction over this matter. The venue is proper. It says the family home on or around November 21st of 2012, while engaged to be married, Eric and Corey purchased certain real property and related improvements located at 282 Willow Court, Francis, Utah. The family home has a legal description of Lot D11, Wild Willow Subdivision, Phase 2D, according to the official plot thereof on file and of record in the Summit County Recorder's Office. Eric and Corey acquired the family home from Eric's sister, Katie Lynn Richens Benson, and her husband, Clinton Allen Benson. Katie Lynn Richens is the defendant and trustee in this case, but she is not being sued in any fashion related to the initial sale of the family home. Eric and Corey each contributed their own separate funds to the down payment of the family home. Before occupying the family home, in accordance with an agreement between Corey and Eric, Corey put the gas, telephone, internet, and electric utility bills all in her name. Eric was not listed on any of the utilities. The utilities have since remained solely in Corey's name. While the utilities were all in Corey's name, Corey acknowledges and agrees that the family home was a joint asset that she and Eric acquired together and held together. Upon closing of the purchase of the family home, Corey moved into the family home. Eric moved in subsequently. After jointly purchasing the family home and moving in together, Eric and Corey each contributed to the monthly mortgage payments. Specifically, since at least September of 2013, all first mortgage payments on the loan they used to acquire the family home have been made from Eric and Corey's joint account, America First Credit Union account. Corey and Eric both funded the joint America First Credit Union account. Although Eric and Corey jointly purchased the family home, jointly paid down the mortgage, jointly paid the utilities, and otherwise agreed and acted in all respects as if the family home was a joint marital aspect, legal title to the family home has remained solely in Eric's name since its acquisition. Approximately 6 months after moving into the family home, June 15, 2013, Corey and Eric were married in their backyard. Corey and Eric jointly resided in the family home, included raising their 3 children there. At all times of the day, from the day they acquired it until March 4th of 2022, when Eric unexpectedly passed away in his sleep. The prenup. Eric's marriage to Corey was his second marriage. His first marriage ended in divorce. Further, prior to his marriage to Corey, Eric had acquired certain assets, including 50% ownership in a business. On June 15, 2013, immediately prior to the wedding, and presumably because of the unpleasantness surrounding Eric's prior marriage and subsequent divorce, Eric's mother delivered to Corey a prenuptial agreement. Oh, that must be fun. Hi, I'm soon to be your mother-in-law. Here's your prenuptial. The prenup, and requested that Corey sign it. A true and correct copy of the prenup is attached hereto as Exhibit A and incorporated herein by reference. Corey complied, and both she and Eric signed the prenup on their wedding day, with the prenup being notarized simultaneously with the wedding certificate by the very same individual. Section 1, Paragraph 5 of the prenup provides emphasis, future income, property or assets. The parties acknowledge to each other that each does not now have, possess, or claim any right or interest in the present, future income or assets of the other, including but not limited to the business known as C&E Stonemasonry LLC. Said business is owned in partnership with the husband and a third party. Wife shall have no right or claim to the business, including its value, its assets, its accounts receivable, whether existing at the time of the marriage or to come into existence after the party's marriage, except that if the husband should die prior to the wife while the two are lawfully married, husband's partnership interest in said business shall transfer to the wife. Similarly, Section 2, Paragraph 1 of the prenup provides separate property of husband. The parties foresee that following the date of their marriage, commingled marital funds may from time to time be spent on or invested in the business C&E Stonemasonry LLC. The parties agree that C&E Stonemasonry LLC shall nevertheless remain the sole separate property of the husband. The expenditure of commingled marital funds on said business shall not give wife a claim or right to an interest in said business, or alter the separate ownership of said business, except that if husband should die prior to wife while the two are lawfully married, husband's partnership interest in said business shall transfer to the wife. Attached as Exhibit A to the prenup is a summary of significant separate property of husband, which lists Eric's assets and debts, the list of assets that were required prior to the marriage. The intent of the list of assets was to give a fair, reasonable, and adequate disclosure of the assets of Eric by category. The list of assets is limited to business assets and includes only Eric's 50% ownership in C&E Masonry, LLC, the business, a forklift, a skidster, scaffolding and saws, 2 trucks, and a dump trailer. Notwithstanding the list of assets showing Eric's separate property, the prenup expressly provides that should Eric pass away prior to Corey, when they are lawfully married, Eric's ownership interest in the business shall transfer to Corey effective upon his death. The list of assets does not include the family home. It does not, nor does the prenup make mention of any real property purportedly owned by Eric. The list of assets also limits personal property to the specific items listed by Eric in Exhibit A. Okay, and let's see, the buy-sell agreement. On or about June 25th, 2019, Eric and his business partner, Cody Wright, entered into that certain CE Stonemasonry LLC buy-sell agreement. At the time of his death, Eric owned 50% interest in the business, and that was subject to the rights granted to Corey in the prenup. At the time of his death, the value of Eric's business interest easily exceeded $2 million. The buy-sell agreement requires that should Eric or his business partner pass away, the surviving partner must purchase the decedent's interest in the business using the proceeds of mandatory life insurance policy carried by both partners. On or around February 16, 2021, Eric purported to assign the business interest to the trust. To the extent that such transfer was even effective, it did not extinguish Corey's rights in the business interest as granted in the prenup. Rather, any such assignment carried with it Corey's vested and pre-existing rights to the business interest as set forth in that prenup. On or around November 3rd, 2020, Eric created and executed the trust, which was to remain revocable until his death. As set forth in Article 1 of the trust, Eric's objective in creating the trust was to provide for both my wife and our children during any time that I'm incapacitated and after my death. Article 1 further provides that all provisions of this trust are to be interpreted to accomplish my objectives. Article 1 also established that initial funding of the trust. Schedule A attached to the trust identifies Eric's assets that were purportedly transferred to the trust upon its creation and execution. Schedule A includes the following assets purportedly transferred to the trust: $10 in cash, unspecified household furnishings and effects, the family home, the business interest, Eric's interest in separate business, Fox Lake Investments, LLC. On or about November 3rd, 2020, Eric purported to convey the family home to the trust via the warranty deed. A true and correct copy of the warranty deed is attached hereto as Exhibit B and incorporated herein by reference. Eric purported to convey the family home without Corey's authorization or knowledge, and on or around that same day, Eric purported to assign the trust all of his tangible personal property, including his jewelry, his clothing, his household furnishings, household furniture and fixtures, chinaware, silver, photographs, works of art, books, sporting goods, electronic equipment, musical instruments, artifacts relating to his hobbies. Eric did not, however, identify any personal property that belonged to him personally, as opposed to belonging to him and Corey jointly as a married couple. A true and correct copy of the assignment of personal property is attached hereto as Exhibit C and incorporated herein by reference. The personal property that Eric owned as of the date of his marriage to Corey is set forth and identified specifically in the prenup. Other than the personal property specifically identified in the prenup, any personal property that Eric acquired during his marriage was joint property, belonging to Eric and Corey jointly as husband and wife. Despite the purported assignment of personal property to the trust, Eric purchased that personal property using funds from his and Corey's joint accounts, and Eric purported to assign the personal property without Corey's knowledge. In any event, the only assets that Eric could have lawfully transferred or assigned to the trust would be his personal assets or his interest in joint assets that he and Corey owned together. Eric could not have transferred Corey's assets or Corey's interest in joint assets to the trust. Article 2 of the trust expressly refers to the prenup and states, "We executed a prenuptial agreement June 15, 2013, which has not been revoked or amended." In other words, pursuant to the terms of the trust, the prenup remains in full force and effect. Eric was the trustee of the trust during his lifetime. Upon his death, however, the trustee became the successor trustee of the trust. Concurrent with the execution of the trust, Eric also executed the will of Eric Richins. The will, a true and correct copy of the will, is attached hereto as Exhibit D and incorporated herein by reference. Similar to the trust, Article 1 of the will refers to the prenup date and states, "This will comply with the prenup agreement my wife and I signed June 15, 2013. In other words, just like the trust, the will acknowledges that the prenup remains in full force and effect. The will requires that all of Eric's probate estate be poured over to the trust and administered under the terms of the trust. On March 4th, 2022, Eric unexpectedly passed away in his sleep. At the time of his death, Eric and Corey were lawfully married, and they had 3 minor children. The following evening, March 5th, 2022, several individuals, including the trustee's sister, spent the night at the family home. The next morning, on March 6th, 2022, oh gosh, I felt something. That was my chain. That was scary. Corey asked the sister to leave to give her time and space and grieve the passing of her husband. Despite Corey's request, the sister refused to leave and began threatening and verbally accosting Corey. After Corey insisted that the sister leave, the sister asserted that Corey did not own the family home and that she would ensure that Corey was kicked out of the family home. Okay. The trustee, through her agents, has also taken the position with Corey and or Corey's agents that the family home and some or all of the personal property of the home belong exclusively to the trust and that Corey has no interest in those assets. Corey incorporates the allegations of the foregoing paragraphs as if fully set forth herein. There presently exists an actual and continuing controversy between Corey and the trust concerning the ownership of the family home. Specifically, the trust contends that it now owns the family home and Corey has no interest therein. Corey, on the other hand, contends that she either owns the family home outright because the home was owned in joint tenancy with rights of survivorship, or alternatively, that she and the trust each own the family home as tenants in common. While legal title to the family home may have been in Eric's name, Corey and Eric both held equitable title, and in fact, Corey and Eric owned the family home as joint tenants with the right of survivorship. Eric's purported transfer of the family home to the trust did not sever the joint tenancy because the transfer did not constitute a bona fide conveyance to a third party. When Eric passed away, title to the family home transferred to Corey as the surviving owner of the family home. The trust has no legal or equitable interest in the family home. Accordingly, Corey is entitled to declaratory judgment from this court that she is the sole legal and equitable owner of the family home and that the trust holds no interest, rights, or title to or in the family home. In the alternative, at the time Eric purported to transfer the family home to the trust, equitable title was held by Corey and Eric as tenants in common. The only interest that Eric could have transferred to the trust was his interest in the family home. He had no authority to transfer Corey's interest. Accordingly, at a minimum, Corey's entitled to an order declaring that Corey and the trust each own an undivided interest in the family home as tenants in common. Corey incorporates the allegations on the foregoing paragraphs as if fully set forth herein. Corey has a valid interest in the family home, adverse to the trust's purported interest in the family home. Corey's interest in the family home is superior to the trust's purported interest in the family home. Alternatively, Corey's interest and the trust's interest in the family home are identical. They each own an undivided interest as tenants in common. Corey clearly holds an equitable interest in the family home because she and Eric purchased it together. She and Eric contributed the down payment. She and Eric both contributed to all first mortgage payments through their joint bank account. The utilities for the home were always in Corey's name, and she and Eric mutually resided in the home as a married couple at all times from the time they purchased it until Eric's untimely passing. Corey is the legal and equitable owner of the family home. She's entitled to an order quitting title to the family home in Corey and declaring that the trust has no legal, equitable, or other interest, right, or title to or in the family home. In the alternative, Corey is entitled to an order finding the legal and equitable title is held by Corey and the trust, tenants in common, and quitting title to family home in Corey and the trust as tenants in common. Corey incorporates the allegations of the foregoing paragraphs as if fully set herein. Therefore, there presently exists an actual and continuing controversy between Corey and the trust concerning the ownership of the personal property. Indeed, on information and belief, the trust asserts that it owns the personal property and that Corey has no right, claim, or interest therein. Corey, on the other hand, asserts that she owns that personal property either outright or jointly with the trust as tenants in common. Other than the personal property identified in the prenup, any personal property that Eric acquired during his marriage to Corey was joint property belonging to Eric and Corey as husband and wife. Indeed, much, if not all, of that personal property would have been acquired through a joint credit account or through payment from joint bank accounts. With respect, oh wow, this is long. Okay, so I didn't realize how long this is. So this is 52 pages, which we're not going to read now because I'm going to fall asleep. But let me go through, hit some highlights, okay? So here's the contemplation of marriage, disclosure by wife, mutual agreement, right to make and take gifts. Okay. Exhibit B. Eric, okay. Oh, those are. Oh, here's his will. His will. Okay, so the lawsuit says that Corey forged documents. Okay, now the sister's lawsuit, family's lawsuit. The sister was followed by a motion asking the court to prevent Corey Richens from profiting from her husband's death. The lawsuit says that Corey forged documents to secure a $250,000 loan using the family home as collateral, and then she obtained a line of credit, both without her husband's knowledge. To obtain the fraudulent $250,000 loan, Corey intentionally used Eric's personal identifying information, including without limitation his name, social security number, birth date, address, telephone number, and place of employment. Without his consent, the complaint says. The suit accuses her of signing a deed of trust on her husband's behalf and then depositing the money into her real estate business accounts, a move that prompted Eric to put his assets into a trust when he learned what had happened. Eric confronted Corey about the fraudulent $250,000 loan in September of 2020. According to the estate's complaint, Corey admitted that she had wrongfully taken out $250,000 in a loan, and she promised to pay it back. Corey also admitted that she had wrongfully taken the stolen bank account money and incurred the fraudulent credit card charges. Corey repeated this promise to pay back the fraudulent $250,000 loan along with the stolen bank account money and the fraudulent credit card charges as late as just a few days before Eric died on or about March 4th, 2022. The lawsuit repeats claims that Eric Richens suspected his wife was trying to kill him, and he spoke with family and friends about those fears. To date, however, there has been no indication that he and his family or his friends have ever spoken to the police about those concerns. The suit also accuses Corey Richens of stealing other property worth more than $300,000 after her husband's death. The lawsuit refers to Utah's Slayer statute, which prevents a murderer or murder suspect from profiting from a victim's likeness or name. Corey Richens' self-published book, Are You With Me?, features a likeness of Eric Richens throughout as an angel. The book was removed from Amazon's publishing platform after her arrest. The suit specifically asked for the court to put Corey Richens' assets into a trust under the Slayer statute, which would prevent her from taking the money during the trial, although she would retain ownership. Corey Richens is being held without bond. Her next court hearing is scheduled for September. Wow, okay, that's a mess. Crazy. Just maybe don't kill your husband. Okay, come on. Oh, I'm feeling tired. I think, let's see, we're gonna... Oh, when he killed his girlfriend. Oh my gosh. These people, I don't understand people today. This is in Maine. Okay, let's see. Come on. So this guy here, a Maine man, he killed his girlfriend. She was undergoing cancer treatment when she vanished. 39-year-old Jamie Schnackenberg was arrested Monday in connection with the death of his living girlfriend, Kimberly Hardy, 42. Hardy's mother reported her missing earlier this month after her family and friends became concerned for her safety. The missing persons post from the Holton Police Department said that Hardy left her beloved cat and other belongings, including her cancer medication, at home before she vanished. During the investigation, the Maine State Police searched a home off of Harvey Siding Road, which subsequently led to the discovery of her body in the woods. According to the Maine Public Radio, game wardens found her body covered in plastic. The investigation led to an area of Harvey Siding Road where a body was discovered by Maine game wardens in a wooded area. Schnackenberg was subsequently arrested at his home in Monticello. The defendant reportedly told at least 2 people that he shot Hardy after an argument, but he denied saying that when police questioned him. Investigators, however, found a gun and blood spatter inside the home. An autopsy is scheduled to determine Hardy's official cause of death. Meanwhile, Schnackenberg remains behind bars without bail at the Aroostook County Jail. Unbelievable. Oh, we've got a little more about Bryan Kohberger. Little something very... He had an arrest in his past. Uh-oh. Daddy called the police on him. So, he was 19 years old when he was charged with theft in Pennsylvania for stealing his sister's iPhone. Uh-oh. Kohberger's father allegedly reported the incident to the police, telling them about his son's apparent drug addiction. After learning of the alleged theft, Kohberger reportedly told his father not to do anything stupid. Kohberger did not serve jail time for the crime, and there is no public record of the arrest. Kohberger, a criminal justice student, former, was arrested in December in Pennsylvania for murdering Maggie Mogan, Kaylee Gonsalves, Ethan Chapin, and Zaina Coronado at the off-campus university home. So that is an interesting thing, right? He was theft. So he did have a drug addiction then, huh? Okay. I don't know. Now, let's see. Alabama wouldn't. Okay. Oh, wow. What the heck? Crazier and crazier. So, who's that? So, an Alabama woman's behind bars for allegedly pushing a missing board pain mother off of a cliff. Loretta K. Carr was arrested Sunday, charged with capital murder, kidnapping, and the death of Mary Elizabeth Isbell. She is accused of pushing Isbell off of a cliff in 2021 after an attempted abduction or during an abduction. The Hartselle Police Department said Isbell was reported missing in November 2021. She was allegedly involved in some sort of theft in an apartment she lived in with her boyfriend, identified as James Allen Wright. Wright eventually transferred to a rehabilitation center in Florida, while Isbell began living where she could in DeKalb County, Alabama. She was possibly at her son's school in Hartselle on November 23, 2021, but she hadn't been seen or heard from since. However, police say that Carr pushed Isbell to her death October 2021. Her Carr remains behind bars at the DeKalb County Jail without bond. No further information is available at this time. And then this is the suspect coming up right over here. Horrible. Wow. Okay. Crazy. But that is just crazy. But I'm getting tired, so we have to play our word game, and because we missed it yesterday and we can't miss it again today, and I have to get back to the chat. Hi, chatters. Hi, cute kitty kitty. Time for our word game. Time for our word game. Tomorrow's our rant night. Be there or be square. And we'll have things we'll have to talk about. I will too. Such a good feeling. No, you're alive. Hold on, I've got to reopen it. Oh my goodness. Hi, Judy. Hi, Annie B. Hi, everybody. How are you? Hi, Video Reel. Calm down, Margot. Tell her, Video Reel, calm down. Tell her to stop. New fee. All right, let me do this. Such a good feeling to know you're alive. Hold on. All right. Let me put Daily Wheel here. Sharon loves this. Come on. 15 reps. All right, we'll do another one. We'll do another spin. I'll move this over here while I clear this. Get away. Goodbye. Good riddance right there.
I got 50 on my spin earlier today.
Oh, well, I'm going to spin again.
It's rare.
Oh.
It's really rare.
I got 50 the other day. I never pay
I
attention.
know you did.
All right, guys.
I only got 15 at an egg lifter, or whatever you call it.
Usually I get 10 and 10.
I'm
It's
going
terrible.
I got 15 and I'm going to spin again. Hey, where's my spin? Okay. Come on, I'm not stopping it. What's going on? Come on, keep going, keep going. I didn't stop you.
Watch when you hit stop, it'll speed up or slow down.
Well, mine is frozen right now,
So
so I have
rigged.
to wait. I better not have lost my thing. Come on there now. I'm just gonna have to hit stop. Okay. 20. All right. Well, we'll take it. 35. I never usually do the second spin anyway, so anything is good. Okay. I'm gonna go to the event. I'm gonna go to the daily puzzle. All right. Okay. Oops.
I just got 15 and then a pointer finger, Sharon.
Oh, that's good. I like that. We call it the kitty scoop and the finger. But yeah.
Let's see here.
Okay, which word do I need?
Compute. Oh, compute. No. Compute. Okay, pewed. P. Pen. And what is that? Yes, it has to be. Oh, shoot. No. Um,
Bless you.
Thank you.
that was a sneeze? I thought that was a cough. Bless you. Oh my gosh. My head is not working. Let me see. Tune, did we do tune? Tube. Um, I tried temp Kevin. Okay, I got that. Got. Okay, so that would be T E E M. Yep. Okay, so far I'm doing it. Me. Did it by myself. I always had one more and I did it by myself. Un. P. Speed up. Temp. Untemp. Unmeet. Umpteen. I've told you umpteen times. Really. Oh my gosh, that's really it. Umpteen?
Yep.
Oh my gosh. Can't even believe that.
You got this, Carolyn.
Oh, that's crazy.
Do you see what time it is?
What?
3:27.
3:27?
Yeah.
I know. I know.
Anybody want to watch a movie?
How did I get that?
Oh, we're doing another one.
Well, this doesn't make sense because it has to be D. I did. That's did. Has to be did. Okay. Dine, didn't I? See, I put dine. Why didn't it go in there? I put it in. I've done. Oh my gosh. Okay. D. H. E. G. Not H. It's going to be E. D. It could still be a G. D. I. No. That won't work. So it's got to be. No, it can't be an N. It's got to be an H. Or an A. H. E. H E Oh my gosh. One more. Sure. Survey.
Yay.
I'm gonna play more of that tomorrow. Gosh, I have to go to bed. I am exhausted. But thanks for coming in. We'll see you tomorrow. We're gonna have our rant night tomorrow, and we'll have a lot of things to talk about. So we'll see you then. Everybody take care. God bless. Prayers for all. We'll see you tomorrow. Take care. Be good.
Bye.
Tired.
Night, everybody.
Hi.
Bye.